Good morning, colleagues. Hope everybody had a good, restful evening and have come in refreshed for the second round of our meeting with the delegation from the Hong Kong SAR in respect of their third periodic report. This is the 2955th session. And before moving on to the second round of questions from colleagues, I'm going to give the delegation some 20 minutes to respond to questions that were left over from yesterday morning. And with that, welcoming the delegation back too, I happily give the floor to Ms. Chang. You have the floor, ma'am.
Thank you, Chairman. There are a number of questions which we promised to try to come back today. If there were any further statistics or figures that which members may wish to obtain, we will try to get it as soon as possible after this hearing. But for today, we have captured a number of questions which we would like to go through, and I would like to first start by inviting our Solicitor General, Mr. Frank Poon, in going over some of the legal issues which were raised yesterday. Mr. Poon.
Thank you very much for coming here this morning and share with us the third periodic report of the Hong Kong SAR. On some of the legal issue, I would like to follow up and give you some more perspective in relation to what we think. The first issue that we want to cover here this morning as a matter of follow-up is the issue raised by a member late in the meeting yesterday on reservation under Article 25B of the ICCPR. We appreciate the further views of the committee on the reservation in respect of Article 25B, insofar as it may require the establishment of an elected Executive Council or Legislative Council in Hong Kong. From the perspective of the Human Rights Committee, we understand and we appreciate the concern of its members that any such reservation should be withdrawn and narrowed down as soon as possible. However, from the perspective of the Hong Kong SAR government, the reservation enables Hong Kong to bring forward our constitutional development towards universal suffrage in a gradual and orderly manner, consistent with the provision of the Basic Law. We consider that it is premature now to withdraw the reservation before our goal of universal suffrage is attained, because if this is done before we achieve a system of universal suffrage that is consistent with Article 25B, there could be, and there certainly would be, domestic legal challenges brought before the Court of Hong Kong to challenge the existing electoral system. At this critical moment in the development of democracy in Hong Kong, we cannot afford to be diverted and distracted from our efforts to implement universal suffrage by unnecessary lawsuits. So for these reasons, and on the basis of the other submission that we made to the committee on this subject in the past, we have no intention at this stage to alter our position as regards the reservation under Article 25B, although we do respect the views of the Human Rights Committee. Another issue that I want to cover this morning is on foreign domestic helpers in Hong Kong. There was a question from a member about why the 7-year rules in the Basic Law does not apply to foreign domestic helpers in Hong Kong. And there is a lot of background on this issue, and I would just want to outline them to you so that you can have a better picture of why we treat foreign domestic helper in the way we do in Hong Kong. There are now over 300,000 foreign domestic helpers in Hong Kong, and they come mostly from the Philippines, from Indonesia, and from Thailand. They are admitted to Hong Kong under a a special or specific labor importation scheme, their stay in Hong Kong is subject to various conditions, including having to live in the household of the employer and not being able to change job to work for another household without the permission of the Director of Immigration. The immigration law in Hong Kong, as well as the policy of the government, is very clear in this regard. The nature and the character of the residence of foreign domestic helpers in Hong Kong shall not be regarded as ordinary within the meaning of the Basic Law. Similarly, the residence of a few categories of other persons, such as the members of the garrison in Hong Kong, the members of the consular corps, consular officials, who are also admitted into Hong Kong for specific purposes, and they are not regarded as having or remaining in Hong Kong as ordinary residents. This is also part of our law. The relevant Basic Law provision is now being used to challenge the above immigration law. So there is an ongoing court case in the Court of Final Appeal in Hong Kong. This was brought by foreign domestic helper who had stayed in Hong Kong for over 7 years, and they are arguing that because of their residence in Hong Kong for over 7 years, they should be entitled to ordinary residence status in Hong Kong. The case has been heard by our Court of Final Appeal in February, and the court will soon deliver a judgment. As part of the government's argument in that case, the CFA was invited to refer the relevant provision of the Basic Law to the National People's Congress Standing Committee for interpretation because of an MPC Standing Committee's interpretation that was made in 1999. And that 1999 interpretation had discussed the legislative intent of the Basic Law provision in question. Whether the Court of Final Appeal would request the Standing Committee of the MPC to interpret the Basic Law is a matter for the Court itself, and it will hand down its judgment in about a month's time. As that case is now being considered by the Court of Final Appeal, you will appreciate that there's not much that I can say here at this stage. Now, the third issue that I want to talk about this morning is on the offences of treason and sedition in the crime ordinance of Hong Kong. A member of the committee raised that issue yesterday in a sense that there was opinion that the offences of treason and sedition in our crime ordinance are drawn too widely and call for the Hong Kong Special Administrative Region government to review the definition of these two offences. I would like to draw the attention of the committee to Article 23 of the Basic Law, which requires the Hong Kong Special Administrative Region to enact local law to safeguard national security. Now, treason and sedition are among the 6 offences specified in that particular article of the Basic Law. We will review the definition for these two offences in the light of Article 23 of the Basic Law and also the views of the Human Rights Committee in this regard, as well as the views of the public, which may be collected in any consultation exercise before the Hong Kong SAR government proposes legislation to implement Article 23 of the Basic Law. Now, while we do have a constitutional duty to implement Article 23, it is not on the top of the priority of the Hong Kong SARG at the moment. At present, we do not have any timetable for implementation of that particular article of the Basic Law. The fourth issue that I want to talk about here is a follow-up to our discussion, our constructive dialogue yesterday, is on the subject of the defense in our crimes torture ordinance in relation to the statutory offence of torture. Now, the view was expressed that the defence that we have built into the ordinance is also too wide. I would first draw the attention of the committee to the object of the crime ordinance, which is to create an offence of torture to comply with Article 4 of the Convention Against Torture. The offence requires proof of intention to inflict severe pain or suffering on another in the performance of official duties, which reflects the definition of torture in Article 1 of the Convention Against Torture, which also requires proofs of intention to inflict severe pain or suffering. A very important aspect of the ordinance is that it provides for the defense of lawful authority, justification or excuse, because under the ordinance, a person may be liable for the offense of torture for intentionally inflicting severe pain or suffering on another for any purpose, as against the specific purposes prescribed in Article 1 of the HRCtte Convention. In other words, the provision in our local legislation about torture, the definition, is wider than that which is contained in Article 1 of the HRCtte Convention. Because of the net that is cast wider by our ordinance, it is therefore necessary for us to provide for a defense so that it would apply when, for example, a doctor gives emergency treatment to a patient whose life is at risk, or when a police officer inflicts serious injury in the prevention of crime. And in these acts, the doctor and the police may inflict severe pain or suffering on the particular subject. So in determining whether the use of force to restrain a violent suspect is reasonable or not, the court would carry out an assessment that is objective, having regard to all the circumstances of the case. And it would consider whether the use of force is proportionate to the harm that it seeks to prevent. So this is the proportionate principle that was referred to yesterday. In Hong Kong, the Court of Hong Kong has developed very well the principle of proportionality in Hong Kong Bill of Rights cases, and we are quite confident that the court in Hong Kong will continue to apply the jurisprudence developed in this regard in relation to the principle of proportionality. In any event, the defense only applies when the public official is acting lawfully. So in our view, it is necessary for us to provide for that defense in our law on implementation of Article 1 of the HRCtte Convention. The last issue that I want to touch on this morning relates to an issue raised yesterday by a member about the number of cases, of court cases in Hong Kong in which the court had referred to the ICCPR and to the general comments of the Human Rights Committee on various articles of the ICCPR. We have given some examples of how the court deal with the various situations. Sometimes in the cases that we have quoted in our follow-up to the list of issues, unfortunately all those cases, 3 of them, they were held, the court held against the government, and we have to do something in relation to remedying the situation. And in the Hong Kong Bills of Rights, the Bills of Rights Ordinance in Hong Kong, Section 6 of that ordinance provides that a court in an action for breach of the ordinance may grant such remedy or relief or make such order in respect of such a breach as it has power to grant in those provisions and as it consider appropriate and just in these circumstances. Therefore, a court may grant a declaration, for example, that a statute or statutory provision which contravene the Bills of Rights to say that it's null and void and is of no effect. So this is something that the court can do. Another remedy that the court may grant is severance. For example, in the Long Kok Hong case cited in paragraph 2.5 of our response to the list of issues, the remedy was the severance of public order in the law and order sense from the phrase public order bracket order publique in the relevant provision of the public order ordinance. And about 2 years ago, after that judgment, we decided to introduce legislation to remove the reference to order publique in our public order ordinance because of that judgment. Thirdly, where appropriate, the court may read down a statutory provision to make it compliant with the Bills of Rights. So it may qualify a certain legislative provision once it has made a judgment on that particular provision, which may decide that part of it is not compliant with the Hong Kong Bills of Rights. Where necessary, the government would introduce legislative measure either to fill the gap left behind by the court declaring a statutory provision unconstitutional or to provide relief to the affected person. So there are various ways in which we could deal with a court judgment which pronounced that a certain part of our law is not consistent with the Hong Kong Bills of Rights. The last example that I would like to give is that after the court had ruled that certain statutory restrictions on prisoner right to vote were unconstitutional, the government introduced the Voting by Imprisoned Person Bill to remove the disqualification of imprisoned persons and persons convicted of certain election-related or bribery offences from being registered as voter and as elector and from voting in the Legislative Council, District Council, Chief Executive and Village Representative election. The bill was subsequently passed by the Legislative Council. So on many such occasions, we do actually introduce legislation to rectify the offensive provision in our law. So these are the remarks that I want to make on some of the legal issues raised yesterday. I want to pass the floor back to our delegation leader, Mr. Chairman.
There were questions about domestic violence, and in the interest of time, I would just like to pick up two aspects concerning domestic violence. One about the figures. It seems that a member has in hand figures which seems to suggest that cases of domestic violence far exceed the number that we provided to this committee. Second aspect is to what extent these figures, the government figures, cover all domestic violence victims in Hong Kong. First of all, the figures. The Social Welfare Department is the responsible department for keeping domestic violence cases and statistics and for taking up integral follow-up actions. The department has set up a central information system on spouse, cohabitant, battering cases, and sexual violence cases. The system will monitor the trend and understand the characteristics of domestic violence and sexual violence cases in Hong Kong. It captures all domestic violence and sexual violence cases reported by the police, the hospital authority, schools, and casework units, etc. These also include cases involving ethnic minorities, women with disabilities, sex workers, migrant workers, and sexual minorities. The system has breakdown of cases by categories. For instance, it will break down cases involving ethnic minorities, women with disabilities, and sexual minorities. However, the system does not keep separate category for breaking down cases involving migrant workers and sex workers, although they are captured in the overall statistics and database. The social workers are also trained to pay special attention to handle cases involving ethnic minority groups, Filipino family disputes, and same-sex individuals. The department also launches the Strengthening Families and Combating Violence publicity program every year, and this was done in a territory-wide and district level through TV program, radio program, school seminars, etc. With regard to the figures, SWD, the Social Welfare Department, is the overall department responsible for capturing domestic violence figures and follow-up actions. However, there are figures kept by other departments for different purposes. If I may quote, Social Welfare Department count domestic violence cases on the basis that the same individual involved in more than one domestic violence case is only counted once. So they are capturing it on an individual or family basis. However, if a victim go to report a dispute to the police station, then the police will capture the number every time an individual report a dispute or a case to the police station. So if we compare, for instance, the figures captured by the Social Welfare Department, which is on a family or individual base, to that by the police station, one may query the police figures may far exceed the figure kept by the social welfare because they are on a reporting. The number of times that you seek police help, for instance. So different agencies will kept different figures on a variety of bases for their different operational need. If there were, if members could give me more detailed information saying that the Social Welfare Department is not including all, we would welcome so that we will follow up. The other aspect is about strip search, the so-called strip search. Although we don't have strip search in Hong Kong, but we have different level of body search. I would like to invite Mr. Patrick Hudson from the police to explain the system in Hong Kong.
Thank you, Madam. A member raised a question yesterday with regard to police searches of persons who are to be detained in police custody.
The mic's gone.
A member raised a question yesterday with regard to the search of persons to be detained in police custody. We reject any claim that searches of persons to be detained in police custody involving the removal of clothing is a common practice. The issue of police searches of detainees came to the Legislative Council interest in 2007, and the subject of police searches of detainees was considered under a subcommittee of the Security Panel of the Legislative Council. After more than a year of detailed considerations, an elaborate system was agreed for force members to conduct necessary searches on persons to be detained in police custody. There are necessary reasons why body searches are conducted. The force owes a duty of care to persons to be detained. We need to be assured that they cannot cause harm to themselves or others. The force has clear directions on the delineation of the scope of searches, and these include a level 1, which involves non-removal of clothing, a level 2, the removal of clothing, and level 3, the removal of underclothing, for which there are 3 subcategories. The vast majority of searches involving the removal of clothing involve the arrest of persons for drug-related offences. A comprehensive range of measures are in place to protect the dignity and privacy of the detained persons, which include the search is conducted in a private search room, the search is conducted on a one-person-at-a-time basis, the searching and the witnessing officer will be of the same sex as the person to be searched, and all searches are approved by the duty officer who is at a supervisory rank. All searches on persons are recorded in the force computer system, which further enhances the documentation process, as well as allowing for comprehensive supervision and management tools on custody searches. Regular statistics on body searches are provided to the subcommittee on the police handling of searches of detainees, and Legislative Council members are at liberty to make inquiries and raise questions surrounding police custody searches. They may make inquiries on specific cases and the reasons why searches were conducted. Thank you, Madam.
I'd like to turn now to death in prisons and claimants, substantiated cases, and human trafficking. On that count, I would like to invite Billy Wu from Security Bureau.
Thank you, Madam. On deaths in custody, as mentioned in our report, there were 101 death cases in custody in the 5-year period between 2005 and 2010. That is on average about 20 cases per year, out of our inmate population of over 10,000 on average. It may also be worth noting that most of these death cases took place in our high security prisons or our only psychiatric center for inmates, where inmates of life sentence or indefinite sentence are accommodated. Under our coroner's court ordinance, a coroner shall hold an inquest with a jury on each and every case died under official custody. Accordingly, all death cases in custody of our Correctional Services Department, irrespective of the apparent causes, had been inquired by the coroner's court with a jury as to the cause of death. Regarding 3 cases in our report where the cause of death is accident, the findings of the jury at coroner's court include heat stroke and head injuries by accident. Separately, under the law, if a medical officer at the Correctional Services Department is of the opinion that the life of any prisoner will be endangered by his continuance in prison, or that any sick prisoner will not survive his sentence, or is totally or permanently unfit for prison sentence, he may recommend to the Chief Executive for decision to have remission on the prisoner's sentences on grounds of illness. And from 2005 to 2010, there are 26 cases of early release of sick persons in custody. And then I will turn to torture claims. Yesterday, a member of the committee noted that there was one torture claimant whose risk of being subjected to torture was substantiated by the Hong Kong Immigration Department. That claimant came from Sri Lanka. So the member asked whether that means Sri Lanka is an established torture risk state, and in this connection, whether other Sri Lankan torture claimants, and if yes, how many, had been rejected by the Hong Kong Immigration Department and returned to their home country. Now, in this connection, I would like to inform the committee that in the years 2010 to 2012, in the 3-year period, the Hong Kong Immigration Department received a total of 136 torture claims from Sri Lankans. Out of these 136 claims, as at the end of last year, 37 were rejected. I must, however, stress that in determining whether there are substantial grounds for believing that a torture risk for a particular claimant exists, the Immigration Department, as the authority, must consider the individual merits of each applicant and take into account all relevant considerations pertaining to his or her case. Now, in this regard, all information provided by the claimant, including the grounds for the claim setting out his or her own personal circumstances and any further submissions with supporting documentary evidence, together with other objective information such as the country of origin information, will all be considered. And reference will also be drawn to, relevant case law, as well as other relevant materials applicable to the individual claim, including, for example, the United Nations Committee Against Torture's general comments on the implementation of the Convention, and also decisions on individual cases. As mentioned yesterday, under the current enhanced screening mechanism to achieve high standards of fairness, claimants are given every reasonable opportunity to establish their claims through torture claim forms, interviews, and making further representations during appeals when necessary. And also free legal assistance is available to all claimants during the entire process. Each decision on a claim must be made individually as to whether the claimant will face a genuine and personal risk. Whether a claim could be established by the claimant is therefore a matter which depends entirely on the particular circumstances of a case. It is not apparent that there should be any correlation between the number of substantiated claims and their country of origin. That said, we would continue to ensure that procedures are highly fair and continue to stand by our commitment that if there are substantial risks established, we will not remove the claimant. Now, on human trafficking, the Undersecretary for Constitutional and Mainland Affairs had already highlighted to you yesterday at his summary of our response to the list of issues that Hong Kong is not a source, transit point, or destination for transnational human trafficking activities. In this connection, we have actually provided at Appendix 3 to our response to the list of issues a summary of statistics on the number of cases relating to trafficking in person during 2006 and to 2011. In essence, during the period, 23 persons were convicted of trafficking in person or related offences during the period, such as living on earnings of prostitution and causing of prostitution of another person. We do have a solid and comprehensive legal framework to combat human trafficking in Hong Kong. Apart from the specific offence against trafficking in person under the Crimes Ordinance, other provisions in the same ordinance and other legislation are in place to combat a wide range of other relating offences, including those involving controlling over persons for purpose of prostitution and procurement of, causing or encouraging prostitution or indecent assault on underage persons. Indeed, Hong Kong attaches great importance to combating trafficking in persons. Apart from the interdepartmental efforts between law enforcement agencies, the Labour Department and the Social Welfare Department on anti-vice operations throughout Hong Kong and offering protection to victims, we also maintain close liaison with, say, local consulates general, overseas counterparts on law enforcement, including the Interpol, and also NGOs to ensure that our efforts on combating human trafficking, which is a transnational crime in nature, will be most effective, and our knowledge on the subject most up-to-date. We also have recently introduced enhancement measures on several areas. On victim identification and protection, the Hong Kong Police enhanced its aid memoir for human trafficking investigations, and it was circulated to all frontline officers to enhance the technique and awareness in identifying and protecting human trafficking victims. On investigation of child pornography-related cases, under steer by a working group, the Hong Kong Police has established a new mechanism to enhance patrol investigation. Any sign of child sex tourism spotted on the internet or through intelligence will now be immediately escalated to the headquarters level for focused investigation by the Organized Crime and Triad Bureau. And also on identification of criminal cases involving foreign domestic helpers in Hong Kong as victims, apart from ongoing investigation, enforcement and prosecution, the police also refined its data processing mechanism to collate statistics involving reported and detected major crime with victims who are foreign domestic helpers and offenders who are their employers. These might include cases like rape, indecent assault, and wounding and serious assault, etc. These figures will facilitate the Hong Kong SAR government in ensuring that sufficient safeguards are in place to protect foreign domestic helpers in Hong Kong and to formulate responsive strategies as necessary. And these are my updates on the three subjects.
Chairman, if I may, finally, I would like to invite our Undersecretary for Constitutional and Mainland Affairs, Mr. Lau Kwong Wah, to talk about two areas, namely sexual minorities and a question about number of institutions providing mental health services.
Some members have showed interest on the work of protection of sexual minorities. The Hong Kong SAR government has been undertaking extensive public education and publicity programs to promote equal opportunities on grounds of sexual orientation. We'll inject more resources, increase our efforts, and strengthen the work on public education and publicity, endeavoring to eliminate acts of discrimination against people of different sexual orientation in society. We will also study relevant legislative and administrative measures adopted by overseas jurisdictions in addressing the issue of discrimination on the ground of sexual orientation for the preparation of work lying ahead. A member also asked some more information on mental health work in Hong Kong. In terms of the number of psychiatric institutions in Hong Kong, there are two designated mental hospitals, and there are 3 psychiatric observation units in 3 other hospitals. And the government also provides a range of subsidized residential care operated by the NGO. There are over 1,500 places in long-stay care home and over 1,500 places in halfway house, and also there are over 80 places in supported hostel for mentally ill persons. In terms of the channels where the patients can complain when their human rights are involved, the hospital authority has a 2-tier complaints mechanism. The first tier is at the hospital level, which is responsible for dealing with all complaints lodged for the first time. The complaint can be lodged to the hospital's patients' relations officers. If a complaint is not satisfied with the outcome of his or her complaint at the hospital level, he or she may appeal to the second tier, namely the Public Complaints Committee of the HA, to ensure that complaints will be handled in a fair and independent manner. All members of the PCC are not administrative staff of the HA. Thank you.
And thank you, sir. Thank the delegation for the responses. Any colleagues wanting to follow up on those responses before we go to the second round? Bearing in mind the possibility that if there are issues that overlap with the second round, you might lump them together. Yes, Mr. Vatslashvili.
Thank you very much. Thank you very much, Mr. Chair. Let me very briefly, just for a minute, go back to the question of interpretation of the basic law by the Standing Committee. From the comments and explanations kindly provided by them, by the delegation, it became clear that authorities are well aware of the views expressed by many that such power may pose a risk to the judicial independence, and even if this power does not in practice limit independence of the judiciary, I got an impression that authorities are somehow cautious that this may be seen by the public as a power actually limiting the judicial independence, and thus, in order to mitigate those risks, indicated that Standing Committee relatively rarely uses this power. So I would be grateful if you could provide additional information on the extent to which this power of interpretation may be used in relation to the Chapter 3 of the Basic Law, which is chapter on fundamental rights and freedoms, and in particular how this may affect the scope of the Article 39, which among other things states that provisions of the ICCPR and other covenants and conventions as applied to the Hong Kong shall remain in force and shall be implemented through the laws of the Hong Kong Special Administrative Region. May this power of the Standing Committee in any way impact the scope of the application of the CCPR on the territory of the Special Administrative Region? Thank you very much. I'll be delighted to hear or read the comments if we run out of the time. Thank you.
Thank you, Mr. Vatslashvili. Any other follow-up questions? Mr. Shani, you have the floor. Mr. Shani, and then Madam Shani.
Thank you, Mr. Chair. I have a short follow-up on the comments made with regard to the individual assessment of asylum applications with respect to the non-refoulement principle. And the question is whether the Hong Kong Special Administrative Region also allows for the attainment of temporary protection for asylum seekers in a mass influx, escaping a mass influx situation, as recommended by the UNHCR in XCOM 22 and 103. Thank you.
Thank you, Mr. Shani. Maintenant, je donne la parole à...
I now give the floor to Ms. Shani. You have the floor, madam. Thank you very much, Mr. Chairman. Very briefly, to conclude with the very serious issue of the interpretation of the law by the Standing Committee of the Popular National Assembly, I'd like to inform the committee members of a text which was addressed by the Hong Kong authorities, sent by the authorities in June 2009 to the Human Rights Committee as part of a follow-up. And it says as follows: since the establishment of the Special Administrative Republic of Hong Kong, the Standing Committee has only exercised its interpretation power when it was absolutely necessary to do so. In addition, the exercise of that power did not infringe and will never infringe or violate the independence of the justice system, the primacy of law, and the high level of autonomy which the Special Administrative Region of Hong Kong enjoys. Thank you, sir.
Merci pour cette
Thank you very much for that clarification, Ms. Shani.
Bon. If there are no further questions, maybe I'll just permit myself, in follow-up to Mr. Shani's question, also ask, and I don't need an immediate response either, whether the Solicitor General can indicate what happened in respect of the other 99 claims from Sri Lanka, the ones that weren't rejected. And with that, I would now go to the second round, and I open the floor to colleagues on that second round. That is questions 14 to 27. And the first speaker on my list is Mr. Flinterman. You have the floor, sir.
Thank you very much, Mr. Chairman. Well, let me first of all express my gratitude for the extensive replies to the questions that I raised yesterday afternoon. Today I will raise some further queries under the issues 14, 19, 23 and 24. Issue 14 relates to the problem of human trafficking in persons. And yesterday my colleague Mr. Rodriguez already raised a number of pertinent questions in that respect, which have been replied to this morning. I'm still left with some questions in this respect. I'm still somewhat confused by the statement in the report and repeated in the opening statement, and once again repeated this morning, that Hong Kong SAR is not a source, transit point or destination for transnational trafficking. And at the same time, we have been informed through the intervention this morning by the delegation and through the replies to the list of issues that Hong Kong SAR is undertaking a wide range of activities in the combat against human trafficking, and that puzzles me. And given that wide range of activities undertaken by the Hong Kong SAR authorities in order to combat the human trafficking in persons, I would like to know the reasons why Hong Kong SAR is opposed against the extension of the Palermo Protocol to Hong Kong, because that seemed to provide for a basis, for a strong legal basis. Of course, you know that's a protocol to prevent, suppress and punish trafficking in persons, especially women and children. And I have one very specific question, both in reading the report and the replies to the list of issues. And this morning, I was wondering what kind of definition of human trafficking is being used in the criminal code of Hong Kong SAR. Is that restricted to the trafficking of women and children for purposes of prostitution, or is the definition much wider, also encompassing other forms of trafficking in human persons, That was issue number 14, and let me now turn to issue number 19. That brings us to some core fundamental human rights belonging to the core of any free and democratic society, the rights to freedom of expression and the right to freedom of assembly. Both rights are not absolute in nature, they may be restricted, but both Article 19 and Article 21 impose very strict requirements as to the restrictions that may be imposed by the authorities. And I would like to draw the attention of the delegation to General Comment number 34, in which the requirements for restricting the freedom of expression have been further elaborated and substantiated by the committee on the basis of its long-time experience in the examination of state reports and individual communications. And I submit that the elaboration of those strict requirements is not only relevant in the context of Article 19, but also in the context of Article 21. In issue number 19, the committee has requested the delegation to comment on some reports which indicate that the police has used disproportionate force and imposed heavy restrictions on demonstrators in a few situations. And I was very much pleased to read in paragraph 19.6 of the replies to the list of issues that on the basis of investigations now specific emphasis has been placed on identifying areas of improvement. And in the report of the IPCC, it is noted that the police has introduced a number of improvements in respect of demonstrations, the freedom of assembly and the role of the police. And I would like to invite the delegation to be somewhat more precise in what kind of improvements have been made on the basis of these reports. And in particular, I would like to inquire whether the public ordinance will be reviewed and whether the Independent Police Complaints Council will be mandated to investigate complaints in a more comprehensive manner, complaints about the suppression of demonstrations and the use of force. And also, I would like to know whether the use of video recording devices and the use of force during demonstrations will be further regulated. And finally, I would like to know whether the use of the Place of Public Entertainment Ordinance to prohibit certain demonstrations, such as the demonstration on the International Day Against Homophobia, will be stopped. Those were my questions under Article 19, under issue number 19, and that brings me now to issue number 23. Issue number 23 relates to the protection of the rights of children, Article 24. And in particular, under issue 23, the right to life of children. We have been informed through the report and through the list of issues on a report on child fatality, which is focusing on the very sad issue of children that commit suicide or and to situations in which parents commit suicide together with their children. A report has been published and we have been informed about the contents of the report to the extent that one of the recommendations of that report, which is to set up a child fatality review mechanism, has been adopted by the government. And that particular panel has started its work in 2008. And I would be interested, Madam Head of Delegation, if it would be possible for you to give us some information on the findings and activities of this panel and of what has been done in order to stop this and to bring an end to the sad situation of children committing suicide. And my final issue is once again an issue relating to the rights of children, the protection of the rights of children, and that is the issue of corporal punishment of children. I was very pleased to read both in the report and the replies that the government of Hong Kong, SAR, is taking this issue very seriously. Very pleased to read, among others, by providing a range of preventative, supportive and remedial welfare services, including public education, parent education, support groups and counseling services. And I was similarly pleased to read that under the Protection of Children and Juvenile Ordinance, care or protection orders proceedings may be initiated when there is a need for the statutory protection of the child. And further, that legislation is also in place to protect children from physical abuse. And I would be interested to know what the practices are under these pieces of legislation. And I did understand that the government is not intending to introduce legislation prohibiting corporal punishment by parents in the home, given the wide variety of views among and within different communities in Hong Kong SAR, and the need of a full discussion by the general public of this important issue. And my question there is whether, Madam Head of Delegation, you could indicate what steps the government intends to take in order to initiate such a full discussion of the problem of the prohibition of corporal punishment by parents in the home. And those, Mr. Chair, were my questions under the issues mentioned. Thank you very much.
Thank you very much, Mr. Flinterman. And I now give the floor to Mr. Newman. You have the floor, sir.
Thank you, Mr. Chair. I'd like to begin by very strongly thanking the distinguished delegation for the highly relevant, responsive, and factual answers that they have given to the questions that I asked yesterday. In some cases, they illustrate areas of disagreement, but I'm extremely grateful for the clarity with which the responses have been given to shed light on the areas of agreement and disagreement. I will be asking some questions with regard to issues 15, 21, and 25, and I hope to keep them shorter than I was able to be yesterday. Question 15 returns to the question of migrant domestic workers or foreign domestic helpers, not with regard to the 2-week rule or the 7-year rule specifically, but especially to the problem of the live-in requirement. The question asked about measures to protect them because they are subject to a live-in requirement that makes them very vulnerable to both physical and sexual abuse and to economic exploitation and a variety of violations of labor regulations. I'm sorry to say that the answer in the reply to the list of issues seemed to me to be very formal rather than grappling really with the realities of the situation that the foreign domestic workers face. It assumes that workers can initiate proceedings for their own protection. But it appears in practical terms that they are inhibited from making complaints by the consequences of a variety of other immigration regulations, because they're isolated by their employers under the live-in system. They have no right to change employers. If they complain, they risk being sent back to their home countries. And in that background, I would like to ask what valid and sufficient purpose is served by imposing this live-in requirement for foreign domestic workers, and why can't they be given more freedom and better protection while they are in Hong Kong? Issue 21 concerns the Falun Gong movement, which is, of course, a prohibited organization elsewhere in China, but generally treated as lawful in the Hong Kong SAR. And I must begin by welcoming the fact that it is treated as lawful in Hong Kong SAR as a demonstration of the efforts of the government of Hong Kong SAR to preserve freedom of thought, conscience, expression, association, and religion. I know that Falun Gong practitioners are not popular in some segments of Hong Kong society. And given the attitude of the national government, the committee needs, may I say, to lend some assistance in making certain that the Hong Kong SAR government remains committed to respecting their rights. The reply to the list of issues takes the position that these practitioners are not subject to discrimination. We have received some allegations that I would like to share with you that raise concerns in that regard. For example, it is suggested that the police do more to restrict peaceful demonstrations by Falun Gong practitioners than to restrict other demonstrators. And there is a decision of the Court of Final Appeal in 2005 that provides evidence lending support to that suggestion. It is suggested that practitioners of Falun Gong are not granted entry into Hong Kong SAR on an equal basis. And there is a decision of the Court of Final Appeal in 2009 that provides evidence for this suggestion, although it did not reach that issue directly. It is suggested that the use of publicly owned indoor spaces for meetings is not made available on an equal basis for Falun Gong events. And this against the background that Falun Gong practitioners face discrimination in the rental of private spaces and may be more in need of the use of public spaces than others. Finally, it is suggested that over the past year, opponents of Falun Gong have physically disrupted efforts by Falun Gong practitioners to disseminate information, and that the police have not protected the Falun Gong practitioners on an equal basis. I would ask the distinguished delegation to comment on these allegations and help shed light on this situation. Finally, question 25 concerns the political rights of persons with mental disabilities. I want to thank you for the answer that's given in response to the list of replies, and I would like to ask the distinguished delegation to help the committee further by explaining more fully with regard to the right to vote. The electoral ordinances disqualify as voters any person who is, quote, found under the mental health ordinance to be incapable by reason of mental incapacity of managing and administering his or her property and affairs. The reply to the list of issues says that the purpose of the disqualification from voting is to ensure that the votes cast at the election truly reflect the free will of the electors and to reduce the risk of voters being subject to undue influence or manipulation, thereby protecting the fairness of the election. My question then is, if that is the purpose, why is the appropriate standard for being denied the right to vote the standard that is borrowed from a different statutory regime whose purpose is to protect people who are incapable of managing and administering property and affairs? I would be grateful for the distinguished delegation's fuller explanation on that point. And with that, I conclude. Thank you very much.
Thank you very much, Mr. Newman. Et maintenant, je donne la parole à Madame Chaney. Vous avez la parole, Madame.
And I give the floor to Ms. Shenny.
Thank you, Chair. Very briefly, given the replies that have already been provided by the delegation to question 16, and 20, with regard to question 16 with regard to jurisdiction, the answer was given in great detail by the delegation, so that's been answered. Just one omission, which was included in the original question. Foreigners. If foreigners are in an irregular status, what is the jurisdictional issue here? And for foreigners in with irregular status, you would also have to add nationals who come from mainland China as well into this category. Given the border towards the Shenzhen area, this is much more closely monitored than some of the other borders.
Des caméras infrarouges et il n'est pas question de passer. Alors c'est un pays, deux systèmes, mais les deux systèmes ont une frontière qui est vraiment matérialisée. Mais il y a quand même des gens qui arrivent à passer. Alors ces gens qui arrivent à passer, il y a toujours des gens qui arrivent à passer devant ce type de mur. Et pour ces gens-là, lorsqu'ils arrivent à Hong Kong, est-ce qu'ils bénéficient, avant de se faire expulser, est-ce qu'ils bénéficient d'une aide juridictionnelle? C'était la question numéro 16. Alors sur la question 20, j'ai pas de chance moi pour les questions parce que à la question 20, on demandait ce qu'on voulait faire, ce que le gouvernement se proposait de faire pour la recommandation du comité qui trouvait que les définitions des offenses, on a déjà parlé sur la sédition et la trahison, étaient trop vagues. La réponse qui a été faite par écrit et qui a été réitérée oralement est de dire, eh bien, on verra ça plus tard. D'ailleurs, c'est quelque chose, je crois, qui est très sensible à Hong Kong. C'est pour ça que on n'est pas encore entré dans le changement de législation. Ça se fera dans le cadre de l'article 23 de la loi fondamentale. Et c'est bien ça le plus inquiétant. C'est que dans cet article 23 de la loi fondamentale, on est encore plus vague. C'est la sécession, la sédition, la subversion contre le comité du peuple, donc contre le gouvernement de Beijing, et les secrets d'État, et enfin toutes sortes de choses, d'offenses qui, quand elles sont très vagues, sont des nids à violation de droits fondamentaux. Et je pense qu'il y a là une telle difficulté que le gouvernement de Hong Kong a préféré reporter l'examen de cette révision de cette loi dans le cadre d'un examen plus général, mais a bien précisé, et je crois qu'il faut le rappeler, et demande à la délégation de renouveler ici son engagement, de le faire en tenant compte des vues du comité sur ce point. La seule question que je voudrais poser, là qui n'était pas dans la question, c'est de savoir si cette législation, telle qu'elle est actuellement, est-ce qu'elle est appliquée? Est-ce qu'il y a eu des poursuites? Merci, Monsieur le Président.
Merci à vous, Madame Chanet. And now I give the floor to Ms. Waterfall. You have the floor, ma'am.
Thank you, Mr. Chair. I would like to thank the delegation for the responses on the earlier questions. I am responsible now for issues on the numbers 17, 18, and 22. Mr. Flinterman has already touched upon the police video taping. What I want to note is that we know that for security reasons and to combat crimes, it may be necessary for police videotaping of public demonstration, but the privacy of the individual should also be taken into consideration. And I would like to know whether there is a monitoring mechanism, because if these actions of the police are not properly monitored, it can raise issues under Article 17. With regard to issue number 18, we have some information here from NGOs, and I want to read it aloud and ask your comments on that. A reporter, and those are issues under the freedom of opinion and expression. A reporter was detained for about 15 minutes for shouting out a question to the visiting Chinese president, Hu Jintao, in June 2012. And because he was carrying out his legitimate journalistic duties. Another incident involved an attempt to prevent a cameraman from filming during a visit of the Vice President in August 2011. Another information is that in early February, the chief executive of Hong Kong sent a legal letter in his personal capacity to the Hong Kong Economic Journal demanding an apology and a withdrawal of the command. The newspaper apologized to its reader instead if they were misled. So I ask your comment on that. Another article is here, or information, that the Hong Kong government has unreasonably delayed the result on granting 3 applications submitted in early 2010 for free-to-air TV licenses for approximately 3 years. And in May 2012, the government confirmed the former Broadcasting Authority had completed the assessment of the licensing applications. It had submitted recommendations to the Chief Executive and Council for final decision according to the Broadcasting Ordinance. However, the Chief Executive and Council vetted the application, and it is believed that the delay is due to political consideration so as to better control public opinion, as the current 2 free TV are regarded as self-censorship and pro-establishment. We also have information that the Hong Kong Radio and Television is it's funded by the government, and it is there's a concern that maybe they are not very subjective. According, with regard to issue number 22, we would like the government of Hong Kong to place more effort in reflecting the views of actors to the mainland of China in order to exercise the right of abode. I thank you.
Thank you, Ms. Waterfall. I now give the floor to Mr. Iwasawa. You have the floor, sir.
Thank you, Mr. Chairperson. I join Mr. Newman in thanking the distinguished delegation of Hong Kong SAR, especially Madam Chan and Mr. Poon for the focused and relevant responses to the questions I asked yesterday. The good report submitted and the focused and detailed written and oral responses given to our questions demonstrate that the Hong Kong SAR government is taking human rights seriously. And I'm very pleased with the level of constructive dialogue we have. And I look forward to continuing a good dialogue this morning. And this morning I will ask some questions concerning questions number 26 and 27 on ethnic minorities. I start with question number 26. The first issue I'd like to take up concerning question number 26 is the issue of political participation and representation of ethnic minorities. I note with satisfaction the efforts made by the Hong Kong SAR government to facilitate the ethnic minorities' access to information at the time of the Legislative Council election held in 2012. I would appreciate it if the distinguished delegation would provide us with information on representation of ethnic minorities in various governmental bodies. First of all, what's the number and proportion of ethnic minorities in the Legislative Council? Also, could you please provide us with the information on the proportion of ethnic minorities in the district councils? What about the advisory and statutory bodies? According to the information before us, among the 460 advisory and statutory bodies, only a handful have appointed ethnic minorities. What measures does the Hong Kong SAR government intend to take to address the issue of political representation of ethnic minorities in governmental bodies? The second issue I'd like to take up concerning question number 26 is the issue of participation of ethnic minorities in the public service. I am aware that after the handover in 1997, proficiency in Chinese is required of all local civil servants in Hong Kong, in addition to English proficiency. Chinese language education for ethnic minorities has not been very effective, I'm afraid, and many ethnic minority residents cannot read or write Chinese as competently as Chinese residents. As a result, ethnic minorities' access to the public service is limited. Furthermore, the lack of ethnic minority nurses, firemen, immigration officers, postmen, etc., adds to the invisibility of ethnic minorities in the social arena. In the report, the Hong Kong SAR government stated that, and I quote, "Where the job does not require proficiency in both languages to the same degree, government departments may set different requirements for the two languages." And in the written replies, the government indicated its intention to specify appropriate Chinese and English language proficiency requirements as part of the entry requirements for appointment to each civil service grade. I underscore the importance of reassessing the language proficiency requirements for each civil service post with a view to making sure that the Chinese reading and writing capabilities are genuine occupational requirement to the post. I move on to question 27. I welcome the Hong Kong SAR government's efforts to integrate ethnic minorities, especially the non-Chinese speaking students, into Hong Kong society. The issue I'd like to raise this morning is the education of ethnic minority students, especially their Chinese language education, which I already mentioned. And this issue was taken up by the International Herald Tribune 2 days ago with the heading "Minorities Caught Between Two Systems." According to information before us, most ethnic minorities in Hong Kong have South Asian and Southeast Asian backgrounds, and students of ethnic minorities essentially have two choices of schools: mainstream and designated schools. Mainstream schools treat all students as native Chinese speakers and accordingly use a curriculum unsuitable for ethnic minority students. On the other hand, designated schools teach minority students Chinese of a too low level for them to enjoy equal opportunities in further study and employment. Of 15,000 ethnic minority students in Hong Kong enrolled in primary or secondary schools, more than half are at designated schools. The Hong Kong SAR, I'm afraid, does not provide special Chinese curriculum to non-Chinese speaking students in a mainstream school, and as a result, non-Chinese speaking students have been marginalized in a mainstream school and attend a designated school. Some commentators in Hong Kong urged the government to implement a Chinese as a second language curriculum. In response, the Hong Kong SAR government stated in the report that offering an alternative Chinese language curriculum with simpler contents for non-Chinese speaking students will only limit the range of their learning opportunities, and that it is fairer to them to have a common and flexible curriculum framework. It remains a fact, however, that due to the poor Chinese proficiency of ethnic minority students, their access to higher education is seriously limited. According to the Equal Opportunities Commission, there is less than 1% of local Hong Kong undergraduates from ethnic minorities, and only 50 non-Chinese local students received offers from Hong Kong universities last year. Thus, the situation is far from satisfactory, and I take note with satisfaction that the Hong Kong Chief Executive pledged in January to do more for minority groups, particularly in terms of Chinese language education. If a Chinese as a second language curriculum cannot be a solution, what should be done and what can be done to address the problem? And I'd like to invite the distinguished delegation to explain how Hong Kong SAR government intends to address the issue of segregation of ethnic minority students in designated schools and the issue of Chinese language education for them. I look forward to receiving responses from the distinct delegation, and I thank you very much, Mr. Chairperson.
Thank you, Mr. Iwasawa. Et maintenant, je donne la parole à Monsieur Benachour. Vous avez la parole, Monsieur.
Merci, Monsieur le Président. La question que je vais poser est relative aux principes qui gouvernent les relations entre Hong Kong et la République populaire de Chine. Et ce grand principe qu'on formule en disant « un pays, deux systèmes ». Je sais qu'il existe des législations spécifiques concernant la santé, l'éducation, qu'il existe une autonomie législative au bénéfice de Hong Kong, qu'il exerce donc par l'intermédiaire de ses représentants conformément à la loi fondamentale. Mais il existe des matières qui peuvent mettre en cause les relations extérieures de la Chine avec les autres pays étrangers. Et c'est à ce moment-là que ma question va prendre son sens, et je vais donner un exemple concret. Est-ce que, la question que je pose est la suivante, est-ce que, par exemple, il existe une législation spécifique à Hong Kong concernant le droit d'asile? Parce que là, c'est une matière qui met en question les relations de la Chine avec les États étrangers. Alors, est-ce que la législation qui s'applique en matière de droit d'asile, c'est la législation de la République chinoise, ou est-ce que Hong Kong dispose d'une loi spécifique en matière de droit d'asile? Je vous remercie.
Merci à vous, Monsieur Benachour. Okay, this is the time for the break to permit the delegation to prepare its replies. Replies both to the follow-up questions in relation to the first round that the delegation addressed at the beginning of the session, as well as to the questions now in relation to issues 14 to 27. So we will now have a
15.
We will now have a 15-minute break. This session is suspended.